How many people here have heard of Dynamex or Dynamics? So some, but about less than half. Okay. This is a huge decision. Why? Many industries use independent contractors. Most. This decision changed the law for purposes of wage orders. And what I mean by that is wage and hour law, basically. There was an old test that basically focused on, does the employer have the right to control your activities? And it looked at a number of different factors, such as whose equipment are you using? Are you in the office? You're not in the office? And a number of other factors. The California Supreme Court said, you know what, that's too complicated. We're going to adopt a really easy test. We refer to it as the ABC test. Just about everybody flunks it. Why? Because you have to meet all three. So what are they? The first one is you got to have, the worker has to be free from control. Okay, so it's the same right of control. Does the employer or the company have the ability to control what you're doing and when you're doing it and how you're doing it, those types of things. That one's an easier standard for people to apply because we've been applying it for years. B is where most people flunk. So what's B? B is the worker performs work that is outside the usual course of the company's business. So what does that mean? Let's take Uber. There was a huge controversy about whether Uber misclassified its drivers as independent contractors. Without getting into the specifics of that case, because that could go on forever. But the issue really was, you got Uber drivers that are making their own hours. They're using their own automobile. They can work as little or as much as they want. They seem like, to many, the classic example of an independent contractor. Under this test, they absolutely flunk, right? Because what is Uber in the business of doing? So Uber tried arguing to the district court, we're in the technology business. And the Ninth Circuit and the district court said, really? No, I think you're in the transportation business because without drivers, you wouldn't have a business. So to me, it looks pretty clear that that is what is Uber's business. It's transportation. Drivers are working within that business. Therefore, they flunk B. Most businesses flunk B. Take a graphic designer. That graphic designer might work for 5 different production companies. That production company is in the business of putting out graphically designed materials. They used to use that person as an independent contractor. That person worked at home, used their own computer, might work at midnight to 2 in the morning or whatever hours they felt like working. They might have fit the test, the old test, that they were truly an independent contractor. But they're going to flunk B because that's the business that the company is in.
Regarding B, now in our legal profession, we have a lot of independent contractor paralegals and even attorneys who work for many different attorneys and law firms. Do they also fail B?
So I'm not going to render an opinion on that, but I think a lot of law firms are looking very, very carefully at B.
Because it seems very similar to Uber.
Be careful.
So
I think that issue came up in the last few years, but
it's come up a lot. Yeah. Well, what's happened is, and C, by the way, is another killer for a lot of people because you actually have to have your own independent business. With a website where you're, advertising out to the public, or you've been doing this for a long time. So in that case, they might fail C as well as B. So what's happened is this has caused such an uproar in the state of California because a lot of people want to be independent contractors. They don't want to be an employee. They don't want to have people telling them what to do and when to do it and all these rules that I'm going to go through in a minute and fly through. So both workers and companies have been pressuring the California legislature to do something about this case. So I actually have some hope that they'll come up with something new to deal with this. I don't have high hopes, but I have some hope because both sides want to see some change in this. So right now, this is the state of the law. It is believed that by many that this is retroactive, and we are starting to see cases being filed on behalf of independent contractors saying, hey, we should have been classified as employees. Why? And this is where I'm going to start flying through this. That's the prior test. It's in your materials. The reason is because if you've misclassified somebody as an independent contractor, there's a whole host of violations, especially if they're non-exempt, right? So you have your driver, and if they should have been an employee, well, they would have been a non-exempt person. They would have been entitled to overtime, right? They would have been entitled to meal breaks. They would have been entitled to rest breaks. They would have been entitled to pay stubs, all kinds of things. Go ahead.
I just have a quick question about the applicability of Dynamex. I know in the slide before, there was a citation to Garcia v. Border Transportation, and it says, wage order claims.
Correct.
But then they go on to list things like failure to furnish wage statements. I mean, that's 226. That's not in a particular wage order. So I was just trying to figure out when they say wage order claims, Dynamex applies, are we talking about if there's, for example, some sort of overlap with the wage order claims? I mean, they do have sections in the wage orders about, record keeping, about meal breaks and things like that. So
this is going to get heavily litigated, the scope of what it means it only applied to the wage orders. And my guess is we're going to see some clarification from the California Supreme Court. And also keep in mind this, that if you've sitting there deciding, all right, I got to make this person an employee for purposes of a wage order, well, that person will then become an employee for all purposes. They're not just a wage and hour employee and for other purposes not. So going forward, they're just going to be classified as an employee. Your specific question, I don't know how that's going to come out. Because right now they're saying it's a wage order. So if you don't find it specifically in the wage order, are they going to say, no, we're going back to the Borrello test? That doesn't really seem to make sense, but I have no idea what the California Supreme Court's ultimately going to do with all of this and whether the California legislature is going to fix it.
I'm actually working on some papers right now, and I think what I'm going to have to do is actually just do it under both tests, Dynamex and Borrello. I think that's until there's further clarification.
Absolutely what I would do. Now, currently, if you have a discrimination or harassment claim, Dynamex isn't going to apply. So if that person was properly classified under the old test as an independent contractor and says, well, I was sexually harassed, you're going to have to use something other than FEHA. You'll use some of those other statutes. Okay.
Thank you.
Flying through this, we talked about that. Everybody knows the overtime rule is 8 hours in a day, 40 hours in a week. Or maybe not everybody knows. Under the FLSA, by the way, they don't have that 8 hour a day rule. It's just 40 hours a week. There's a strong presumption that a person is an employee and non-exempt. So you start with that. What happens if you get it wrong? Lots of penalties. Individual, there can be a class action, and there can be a private attorney general act claim. And what I'm going to just say for PAGA really quickly for those who don't know what it is, many years ago, our California legislature decided that there are so many labor code sections that can only be enforced by the Labor Commission. They don't have enough people to go out and police all of this. So they came up with the idea that we're going to basically make each employee a little private attorney general who can police it on behalf of them.